Thank you for joining Jennifer Schaus and Associates in our 2019 Webinar Wednesday series. We are coming to you live from downtown Washington, D.C. Our webinars are every Wednesday, and you can find the upcoming schedule on our website. Past webinars and all recordings are also on our website and on our YouTube channel, along with over 160 other recordings on federal contracting topics. All are complimentary. If you have questions for our speaker today, you can email her directly with the contact information you'll see on your screen. And just a little bit about us. We are a Washington, D.C. based firm, and we provide services for federal contractors. This ranges from market analysis reports to proposal writing and also post-award compliance. More information is on our website, so please visit us there. We do offer advertising, so you can email me if you'd like more information on that. And Amelia Schmidt and Jennifer Short are going to be our speakers today, and they're going to be covering False Claims Act compliance, operation, and credit. Thank you guys for joining us, and I'm going to go ahead and hand it over to you.
Thanks, Mallory. Hi, everyone. This is Amelia Schmidt. I'm here with Jennifer Short, who hopefully you were able to catch in the presentation she just gave in the noon to 12:30 slot on the False Claims Act, basics and big picture. And with that, we're going to talk in a little more detail about what it looks like if a company has or thinks it may have a violation of the False Claims Act on its hands, and where we go from there.
Yeah, so we talked in the last half hour about all of the risks that come with potential False Claims Act liability, and now we're going to talk about compliance and cooperation and credit with the Department of Justice. Okay, so why are we talking about this?
Sure. So we're talking about it because if you tune into Jennifer's webinar, or if you follow some of this in the news, you see the False Claims Act everywhere, and it's a huge issue for companies that have government contracts, especially because the way the law works, again, as Jennifer was talking about, DOJ can seek up to 3 times the amount of actual loss that it claims that it had if there's a False Claims Act violation. So that's also called treble damages. And if we could go to the next slide, Mallory. Yes, perfect. Like we were saying, companies can face treble damages in False Claims Act cases, but there are also ways they can try to avoid or mitigate that if they get into a situation where either they think they might have a violation and they decide to disclose it to the government, or if DOJ or whistleblowers are accusing the company of violating the False Claims Act. If those things happen, the company has a few options. They could decide to fight the allegations in court, or they could try to negotiate some kind of a settlement with the Justice Department. Hopefully, you will never be in this situation, but if you are in the middle of a False Claims Act investigation, it can be a nightmare. There's a lot of, and things happen very quickly. There can be a lot of fact finding. It can involve a lot of complicated issues. You have to make a lot of judgment calls, sometimes in a very compressed time frame. You probably have to have a lot of discussions with your lawyers, and you have to figure out how to handle company morale and deal with the fallout that can happen with a False Claims Act case. So with all those kinds of terrible things that can happen, it can be useful, even before you get there, to think about and things for you to know about that we'll talk about today that will help you if you ever do get stuck in this place. And if that happens, compliance is going to matter and cooperation is going to matter, because that can go a long way towards the Justice Department agreeing to reduce fines if you decide to settle the case.
So, all right, so compliance and cooperation matter. So why do they matter? Should we go to the next slide?
Sure, yes. Great. So until recently, the understanding was that DOJ would not settle with a company for any less than double the amount of damages, which made it very difficult for companies thinking about whether to go in. And Jennifer, if you want to speak to any of that, your thoughts are great.
We'll talk later about that.
Sure.
All right, so let's talk about compliance programs. Like, why does compliance matter?
Sure. So compliance matters because, So compliance matters because again, until recently, it wasn't very clear where DOJ was going to come down. If you were in that room with DOJ and you're talking about settling a case, there wasn't a lot of transparency into what was going to go into what DOJ was going to say you owed them. So recently, in May, there was a huge change when DOJ issued these changes to the Justice Department manual that gave a stated policy in writing that DOJ is going to consider compliance and cooperation in deciding what the damages should be and what their position would be with companies in negotiating a settlement. It's not everything, but it is really important because before it was really much more of a black box as to what DOJ was going to be thinking about. And this is at least something in writing that tells you, a company, that compliance and cooperation are going to matter.
So what goes into, how is DOJ looking at compliance and compliance programs?
Sure. I mean, really, it's the start point and the end point, because in their minds, it goes to how you ended up here and how you will make sure it doesn't happen again, or how you will try to make sure that it doesn't happen again. The concept of compliance as mitigating factor has been around in criminal cases for a very long time. So the U.S. Sentencing Guidelines has a whole very long list of factors in Section 8B2.1. Again, the criteria I've put here is just a very high-level summary of what I think the main themes are in the list, but it's a floor, not a ceiling. Like, these are all things that that in a criminal case a company would be expected to meet if it were found guilty and we're trying to negotiate some kind of a plea deal, or we're being sentenced in a criminal case. So what matters in the sentencing guidelines? What matters is is high-level buy-in, basically. Did the governing authority know about a compliance and an ethics program? What kinds of oversight was involved, and who was buying in, and who was responsible for oversight and for enforcement? So you want high-level personnel of the organization to ensure that the organization had an effective compliance and ethics program. But you also want them delegating day-to-day responsibility to individuals. Depending on the size of the company, it could be one, it could be more people, but someone that employees will know to go to if they have questions, just on a day-to-day level. I mean, no one is expecting the CEO to be the front lines for for every daily compliance question that comes up. But again, this goes back to people at the high level needing to buy in and needing to support a compliance and ethics program, but also they need that to trickle down to the whole company. So that includes, again, delegating day-to-day responsibility to lower level personnel, but it also includes effective communication. What does training look like? How is compliance regarded? Is it an important value? Is it part of the company's culture? And to that point, how much is the policy actually enforced? Is it just a piece of paper that no one really knows about or reads, and everyone is sort of kind of giving a wink to compliance, but everyone knows? If you go into a company and you find out that, yeah, everyone knew that there was a compliance policy, but we all knew that we didn't actually have to comply with it. That's a problem. So communication, high-level oversight, and actual enforcement, I think, are the main ways to sum that up. And also, I think this is important to add, that a company is taking it seriously by evaluating and stepping back and thinking about whether it makes sense to ever tailor the compliance program. Your company changes, and so it may make sense for you to change the compliance program with it. So if you're talking with DOJ and they're looking at your compliance program and it's something that hasn't been updated for years, and maybe it was drafted when it was just a 3-person operation that's since grown to a 300-person company, DOJ is going to want to know, well, why wasn't this updated? And maybe this wasn't enough, and you should have known that it wasn't enough to prevent violations from happening.
Right. So you're talking about the Department of Justice looking at your compliance program, and hooray, sentencing guidelines in the criminal context. But how does that work in a civil False Claims Act case?
Yes, exactly. Move to the next slide, please. So again, like Jennifer points out, we've been talking about the sentencing guidelines in criminal cases. So as part of the changes, well, I was talking about the DOJ manual that was updated. So in the DOJ manual, there's also language that says any evaluation of a company's compliance program needs to take the factors into the sentencing guidelines into account. So that's why all of the things I'm talking about are important. I think that, you know, this is something that's been around forever in the criminal context, but it's something that DOJ lawyers that you're talking to in a case are going to know about, and they're going to be thinking very seriously about.
So this is civil division lawyers actually now connecting the dots between the sentence in the sentencing guidelines and saying, look, from a civil perspective, we're going to look at this when we're negotiating a settlement of False Claims Act. Did I connect those dots correctly?
Yes, you did.
Awesome. So what else is in the Justice Department manuals?
Right. So the manual also talks about disclosure. So that's on the slide here, disclosure, cooperation, and remedial measures. We talked about compliance, but I think maybe it makes sense to move to the next slide when we talk about what disclosure actually means.
Yep.
Great. So disclosure can mean different things in different contexts. There's what the DOJ manual says, which I'll get into in a minute. There's also what regulations require, which again I'll speak to in a minute. But I think if you're ever dealing with this, usually the most immediate thing to try to figure out is what, if anything, your contract requires in terms of disclosure. So you'll need to look at your contract. You'll need to look at, and it's tricky because you'll need to look at both whether there is anything, you know, is the word disclosure actually used in the contract. But sometimes, if those of you who you know, are more sophisticated in this area will understand, a lot of government contracts do this thing called incorporating by reference, where they put in they'll put in one line that says this section of the federal acquisition regulations applies, and they don't actually tell you what that says. So you have to go to the regulations and look it up. So that's why we also want to talk about what disclosure means in a regulatory from a regulatory standpoint. The FAR, the Federal Acquisition Regulations, have a section in there called the Mandatory Disclosure Clause, which it won't be in all government contracts, but it can be in quite a few. And that one will say that that a contractor has to timely disclose if they have any credible evidence that a principal, employee, agent, or subcontractor committed a crime or committed a violation of the Civil False Claims Act. And again, the credible evidence requirement is important. It doesn't, you know, the mandatory disclosure provision, you know, it can arguably apply like well before, you know, you and DOJ are even talking. It becomes, and it becomes difficult to figure out when you need to approach your government customer and your government customer's Office of Inspector General if this mandatory disclosure provision applies.
So let's say that you see, you're a contractor and you see an issue and you're debating around this fuzzy standard of do we have credible evidence of a potential violation, and the decision is made, yeah, we think we do. We think the mandatory disclosure provision applies. We're going to go ahead and make a disclosure. That typically goes to the contracting officer, to the agency, the government customer. Does that cut it when you are then, say, months or years later, sitting in front of the Department of Justice trying to get credit in a False Claims Act case?
Yeah, I'm sorry. Can you repeat the question?
Yeah. So let's say you understand as a contractor that you have a regulatory or a contractual obligation to disclose, and you've made that disclosure. Is that disclosure going to get you credit when you're later talking to the Department of Justice about trying to resolve a civil action under the False Claims Act?
So I think, and you know, your thoughts on this are welcome too, but I think that it depends, right? Mm-hmm. If you did make that disclosure, I mean, what did that disclosure look like? What did how did that turn out? Maybe the agency, maybe the agency thought you handled it well, and you also conducted an investigation that compiled a lot of evidence that can be used. But I mean, the flip side is, right, if you waited too long and didn't go into DOJ, I think that DOJ may be less inclined to give you credit, but I think that ties into the DOJ manual and the different factors that DOJ I said I was going to come back to. So thank you for bringing me back there.
And I think overall the point is there are lots of, when you are faced with those disclosure questions, is this something that we need to disclose? There are different avenues to go down. And to go different considerations.
Yes, and different players involved too. I mean, you have DOJ, there may be local AUSAs involved, there's going to be a government customer, depending on the situation, the government customer may have its suspension or debarment office involved, which can be very, very scary in its own right. So there's a lot of different considerations, and that doesn't even go to what I think the slide touches briefly on this, but there are voluntary disclosures too. Even if a company doesn't have to, sometimes they decide it makes sense to because the government agencies will give you some kind of credit for that. We see this a lot with clients who do business abroad and have to comply with export controls and sanctions laws. The agencies, like the Commerce Department, the State Department, Department of the Treasury, all have their own disclosure regimes, and you don't have to, but if you make the choice to go in and disclose a violation, that can also be beneficial. So I do want to touch quickly on tying it all back to the DOJ manual. I mean, what DOJ is going to be thinking about is, like we were saying, timeliness and voluntariness, how truthful you were, how open you were, and the significance and usefulness of the cooperation to the government. So maybe that takes
so
cooperation.
Move to cooperation.
Yes. Yeah. Cooperation. So what does cooperation look like? There are a bunch of factors. If I could go to the next slide, they'll list some. Please. Thanks. So cooperation, it includes a lot of things. Like with the sentencing guidelines, what I've provided here is just a really high-level list of things that cooperation can look like. But it's, I think, generally going to involve prompt and full disclosure. Maybe there are extenuating circumstances, and of course there's a lot of room for debate about what is prompt and what is full disclosure. But that's important. Did the company preserve and produce relevant evidence? Again, a lot of play in the joints about what relevant evidence means. The DOJ will also be, they'll be looking to whether a company is willing to hold people accountable to the extent people need to be held accountable. And that can mean a lot of things. That can mean, trying to identify or maybe discipline employees who were bad actors. It could also just mean making individuals who, may not have done anything bad but have relevant knowledge of the situation and are witnesses, making them available for interviews with the government. It can also include trying to assist the government in recovering its losses. If there are ways to make the government whole, what's the company's willingness to work with them on doing that?
So say I'm with a company that's under investigation. Do I get cooperation credit if I produce all the documents that are responsive to a document request?
Maybe. Which is, go ahead.
Well, it certainly can't hurt, but I think the notion behind cooperating with the Department of Justice is sort of going above and beyond what is merely legally required. Do I understand that right?
I think that's fair. It's not about just checking the boxes from DOJ's standpoint. It's about really being invested in compliance and in taking the law seriously and working to make it right.
So, I think going back to the DOJ manual, and I want to move you on to the next slide because we're going to run out of time again.
Yes, the next slide, please.
And so the Justice Manual is also makes reference to remedial measures and companies that take remedial measures. What role does that play in the calculus?
Sure. So remedial measures can involve a couple different things. There's a lot of talk in this space about monitors, which sometimes DOJ may require that a company do as part of a settlement. That means what it probably sounds like. You hire and pay for an independent compliance monitor to come in and oversee your compliance function for a period of time to be agreed upon, and if the monitor has concerns about you're not complying, then that can create problems from a settlement agreement perspective, where DOJ can accuse you of having breached the settlement agreement. So it's a serious thing, and there has been some guidance from the criminal division, not from the civil division, but I think, for similar reasons to what we already talked about, the civil division lawyers will be thinking about similar things too. But the criminal division last year put out some guidance about when lawyers in the criminal division should consider whether a monitor is appropriate. I mean, it really comes down to a cost-benefit analysis. Like, monitors should not just be used just to punish a company. They should be used, they should actually bring some value to the table. So some of that involves, if DOJ is thinking about, in the criminal context, whether to require a company to get a monitor, that can, it comes into thinking about, what the violations look like, what the investigation, how the company conducted itself in the investigation, and what the risks are of repeating misconduct. So that's, yeah.
Yeah, I was going to say, so are there things that a company who wants to cooperate with the government and get credit with the Department of Justice, are there things for short of offering up or agreeing to a monitor, a compliance monitor, that companies can do? Are there ways to use their compliance program, for example?
Yeah, I mean, it comes back to compliance, exactly. So that, that's why I said earlier, DOJ considers this the starting point and the end point. So what are you going to do to your compliance program? If we're not going to get a monitor, what are you going to do to fix this? So I think that involves, like I was talking about, stepping back, evaluating your compliance program to the extent you haven't, and thinking about, what if any holes were in here that let this happen? Or was the issue a structural one? Is the problem with the program, or is the problem in how it was communicated? Did an employee just honestly misunderstand something, like there was a wrong message given in the training and they didn't know any better? Or was it a situation where the problem was a lack of enforcement? And this goes back to what I was talking about, a culture, or if an employee felt, it's just really important that we make the sale, or that we get this contract or this award, and, I know that there's policy, but the company doesn't actually take it seriously, so I'm just going to go ahead and violate it.
Okay, so it sounds like all of this cooperation, compliance, remediation can be pretty expensive endeavor on its own, and then to go to the government and throw all this stuff out there. What do contractors get in return if they decide to go through this painful exercise?
Yes. So back to damages and credits. Could we get the next slide, please? Great. So back to damages and credits. The government can take credit into account in figuring out how much, if there's some argument at the table about how much your damages are going to get multiplied by. So this comes back to the notion of treble damages and getting to multiply, is it double damages, treble damages, or is it something else? But I mean, there's a meaningful difference there, right? 1.5 times the amount of what you've agreed the settlement amount's going to be is meaningfully different than 2.5 times that amount. So that's where cooperation and compliance and all that stuff come into play. So again, it can be monetary. You're looking at single damages plus costs instead of treble damages. But there's also some non-monetary things that can be really important. Sometimes DOJ may agree to publicize the fact that when they announce the settlement that the company was cooperative. We talked about multiple players being involved. DOJ can may be willing to talk to other agencies, including suspension debarment officials, and make some recommendations based on how they thought the company conducted itself in the negotiations. And also, DOJ can negotiate with, if there's a whistleblower involved, they can negotiate with the relator in terms of what they think is appropriate from a damages standpoint.
So this is excellent, and these credits that's how DOJ has articulated what defendants can the potential upside of coming in and doing all of this. And they've just articulated that in May of this year, so May 2019, in this Justice Manual provision. So we'll see how this actually plays out in practice. It'll be interesting to watch the settlements and see the negotiations happen in real time, to see how serious DOJ is about offering up those sorts of credits. But it's a start.
Right, exactly. It's a start.
Very good.
So thank you to everyone who participated. This was fun. Thank you, Jennifer. and I think we can go ahead and sign off.
Super. Thanks. Thank you.
Yeah, thank you, Amelia, and thank you, Jennifer. If any of you have questions for them, please contact them at the email or phone number shown on your screen. And this concludes the webinar for today. Thank you, everybody.